Welcome to the 2023 Justice and Treatment Partnerships Conference that is hosted by the Association of Justice and Treatment Professionals. My name is Justice Barnes, and the Association of Justice and Treatment Professionals tries to create a forum where persons, experts who work in areas where justice and treatment intersect, and persons who work in areas that touch on the social, economic, and other determinants of crime work in an effort to share ideas, to learn from each other as we move forward. We are very fortunate to have some experts to speak to us today on our first plenary. And what I will indicate is that at the website www.justicetreatment.org, you have extensive information on the biographies of the experts and all the persons who I'm going to be referring to today. I can tell you that this session will be recorded, and the recordings will be available on the website and will be sent to participants. This conference came about through the work of the persons you see on the screen: Brian Cooper, Aline McGinty, Megan Oliver, Carol Sinclair, and myself. And we've been able to, with the assistance of the subject matter experts that you're going to be hearing from in the next 3 days, been able to put together 6 plenaries on interesting topics for your the word consumption comes to mind, but certainly for you to listen to and learn from the respective experts, for all of us to do that. The topic for today is, as you can see, evaluating a mental health screening process. And there is a process in a youth criminal court, and the subject matter experts for us today are Michele Peterson-Badali, and it's Dr. Michele Peterson-Badali and Aminah Chambers. Tonight, or today, is still the afternoon, we have a moderator. And the moderator who is actually going to take charge of today's proceedings is Brian Cooper. Now, Brian Cooper is a program manager with St. Joseph's Healthcare Hamilton, and he holds responsibility for acute mental health inpatient care, the Cleghorn Early Intervention in Psychosis Clinic, and SCIS Inpatient Rehab Team. Brian is the co-chair of Early Psychosis Intervention Ontario Network and director at large with the Canadian Consortium for Early Intervention in Psychosis. As an occupational therapist, Brian has worked in a number of primarily mental health settings, including inpatient care, assertive community treatment, and early intervention in psychosis in Ontario, Nova Scotia, as well as Newfoundland and Labrador. Brian has led various community development projects and funded research initiatives that range from setting national standards for transition for youth in mental health care to economic evaluation of early psychosis services and cross-sectorial support in employment and mental health care for youth and young adults. And as I said earlier, there will be times when we may not necessarily read out the entire biography of a subject matter expert. We may simply give you the highlights, and you can get the full information on each of our subject matter experts at www.justicetreatment.org. Having said that, I turn everything over to Brian Cooper.
Well, thank you so much, Justice Barnes. And thank you so much, everyone, for joining us today. We're really thrilled for a great number of sessions, and we're starting it off with a bang. This is one I'm particularly interested in, so really excited to hear about it. So before we get rolling, we just want to have a few pieces to touch base about first. First and foremost, we do want to offer a land acknowledgement. So I'm calling in from Hamilton, Ontario, which those of you who might be outside of this area, it's just outside of Toronto. But the city of Hamilton is situated upon the traditional lands of the Erie, Neutral, Huron-Wendat, Haudenosaunee, and Mississauga people. This land is covered by the Dish with One Spoon Wampum Belt Covenant, which is an agreement between the Haudenosaunee and the Anishinaabe to share and care for the land and resources around the Great Lakes. This land is also covered between the Great Lakes Purchase of 1792, which was between the Crown and the Mississaugas of the Credit First Nation. And I just want to say, from my own perspective, I acknowledge that my own place in Canada started when my family immigrated here from the UK in the early 1900s. And in doing this, I recognize that part of my place here in this country is one that was in part due to traditional colonial practices that have resulted in trauma to the land and to its first peoples that is still felt to this day. So in saying that, I do want to personally commit to humbly committing to learning from, sharing with, and growing alongside the first peoples of this land. As far as today's topic goes, just one piece of housekeeping is just that the Q&As, so if you have any questions, the presentation will be roughly about an hour, and if you have any questions, I would just ask you to put them in the Q&A and not in the chat at the bottom. As Justice Barnes mentioned, this session will all be recorded, so you'll have the opportunity to review it later or share it with your friends, and we will have time for questions at the end of this session. So, and again, on behalf of the Association of Justice and Treatment Professionals, I'm really excited to introduce our first speakers today, Dr. Michele Peterson and Aminah Chambers. And they're going to be talking about evaluating a mental health screening process for in youth mental health court, which again is something in my area of interest, in my area of work, I'm really, really excited about learning about. So Dr. Michele Peterson-Badali is a professor in the Department of Applied Psychology and Human Development at OISE at the University of Toronto. She has taught in areas of professional psychology, ethics, child psychology assessment, and children's psychology in the law. Her research examines issues in youth and criminal justice psychology, which we'll learn a lot about today. Her current projects focus on effective assessment and intervention for justice system involved youth and mental health. And in addition to this work, she is actively engaged in bringing her research findings to the spheres of public policy and practice, and has conducted research and provided policy consultation to Canada's Department of Justice, and provided consultation and training for various youth courts and probation offices, and served as expert witness on the Ontario Advocate for Child and Youth. And Aminah Chambers, who's also joining us, is a PhD student working under Dr. Peterson-Badali at University of Toronto in the Youth Justice Lab. Her research interests are in the area of adolescent mental health, improving outcomes for youth, justice-involved youth. Using both qualitative and quantitative methods, her research focuses on examining court processes for youth and their families who encounter mental health issues. Encounter the justice system in ways that the courts can identify and address complex needs of youth and mental health issues. She's also interested in factors that contribute to the justice system, disparities for marginalized youth, and identifying the risks and strength factors for criminal offending justice-involved girls and women. So with that all being said, I'm really excited to hand it over, and I look forward to a great talk and learning a lot about this very interesting subject.
Perfect. Thank you so much for that introduction. I will share my screen. Everybody can see that?
Yep.
Perfect. All right. Well, we had our introduction.
So I will start. I think we'll be less than an hour in terms of this presentation, because we really want to leave a lot of time for questions and discussions. We're really interested in what people have to share, their thoughts, their questions, and so on. But we wanted to start by just giving a little bit of an overview of this research lab at the Ontario Institute for Studies in Education, which is where I've been a faculty member for a long time, coming on 30 years now. And I'm at almost 40 years in terms of my interest in these kinds of issues, which started as a graduate student at the University of Toronto. And so we come together to really try to think about issues and questions that are real world issues and questions out in the justice system. And we try to work collaboratively with partners to answer those questions. And so from my own trajectory, that started really way back when when the Young Offenders Act came into force, which, as many of you know, I'm sure, really represented a shift away from a kind of child welfare model of youth justice to a rights and responsibilities or an accountability model. And so as part of that, young people had rights enshrined in the act in terms of and were going to be instructing legal counsel and so on. So I was really interested in understanding what young people's capacities were in that regard. So that led to a whole program of research, really looking at young people's knowledge, their reasoning, their perceptions, and their experiences of and with the youth justice system. And in more recent years, I've collaborated really extensively with Dr. Tracy Skilling, who's a forensic psychologist at the Center for Addiction and Mental Health, who really heads up a service that does a lot of work in assessing young people before the courts, doing Section 34 assessments. And so we've worked together for a long time now in really trying to understand how to really engage in best practice in terms of assessment and intervention with youth involved in the criminal justice system. And that's including looking at what are the relationships between, identifying the criminogenic needs of young people, addressing those needs, and reoffending. And most recently, we're really spending quite a bit of time in two areas. And one is really looking at the validity of the tools that we use in assessment. So the kinds of tools and instruments that Tracy and the folks in the forensic unit at CAMH use to assess young people, really looking at the validity of those tools to ensure that they are measuring the concepts that they're supposed to measure in a reliable and valid way, and doing so across groups. And so often tests have been validated on maybe predominantly white male samples, for example, and we don't know whether those tools are working the same way and working effectively in, for example, racialized groups, or working effectively for females as well as males. So that's one piece. And the other piece that's going to lead into the talk today is really thinking about that nexus, that relationship between mental health and justice system involvement, and really trying to understand the role of mental health in reoffending, and examining programs that have been developed to address the mental health needs in the youth justice context. And that's what's led to a couple of wonderful partnerships with the Downtown Toronto Youth Court and with TPYS. So that's what we're going to jump into when we talk about predominantly this mental health screening program that was developed.
Thank you, Michelle. So this work comes out of the dissertation that I'm doing in the Youth Justice Lab, and it is a process and outcome evaluation of a systematic mental health screening program in a youth criminal court. The picture is the 311 Youth Court where this all happened. And so it's important, this audience will know this, but it's important that programs are evidence-based. We have a duty not to cause harm to the people who are under our care. But there was a 2014 study that showed that 22 justice interventions were harmful. For example, Scared Straight didn't show any desirable effects, showed undesirable effects. Boot camps were kind of mixed. They had some desirable effects, some undesirable effects, and a lot of no effects. And the same thing with drug courts. They had some desirable effects, a lot of no effects and a little bit of undesirable effect. But even interventions that show no effect are a kind of harm, because people who could be participating in programs that could help them instead of using their time or resources ineffectively. For example, in the Ontario Youth Justice System, there's a limited amount of time that youth are in the system to provide programming to youth. So it's important that what programming they do receive actually meets their needs. One question we have is, how do well-intentioned programs cause harm? There are a couple mechanisms proposed. I'll talk about just two of them today. One of them is theory failure, which is when the basic idea or mechanism of prevention was unsound. And the use of a logic model can minimize this. You need to be able to connect your planned activities and how you expect them to cause the outcomes. And you need a strong theoretical link between your planned work and your intended results. And we believe that this was the issue with Scared Straight. It had a general deterrence theory behind it, but how the activities were supposed to connect the results wasn't theoretically strong. Another type is implementation failure, where the idea was sound, but it wasn't properly put into effect. And we can't assume that programs will work in all contexts. For example, a program that was developed in one context, like a lab or a clinical setting, being used in another setting, like corrections, for example. So we need to understand what a program is and how it works in order to be able to assess whether it's doing what it's supposed to be doing. I don't usually read from slides, but this part's really important, so I will. Implementation science is the scientific study of methods to promote the systematic uptake of research findings and other evidence-based practice into routine practice, and hence to improve the quality and effectiveness of services. So outcomes are important, and that's what usually people are focused on, but understanding processes are important too. Part of implementation science is contextualization, explaining the context of the original study. So if establishing that a program is effective is not enough. When outcomes are poor, we need to understand why, but you can't answer the question of, was it the program or was it something else, if you don't know what the program is supposed to be doing and how. The other part that's important is understanding the program gives the practitioners the opportunity to understand what can be adapted in real-world settings while maintaining the integrity of the program, which is important. So the National Implementation Research Network has a great framework that I've used for this dissertation, and it's the Usable Innovations framework for evidence-based programs and practices. And they have laid out the things that you need to make sure that an innovation or an intervention is usable. So those are a clear description of the program so people can understand exactly what the program is and the context in which it was developed, a clear description of the essential functions of the program or the activities so that you know what it's supposed to do and how. Operational definitions of program components is what you need to run the program, and practical fidelity assessment. Fidelity assessment is basically quality control, so that you know what was supposed to be done was actually done in your program. So today we'll talk about three implementation science evaluations that have gone on in the Youth Justice Lab. The first is a process evaluation of the 311 Jarvis downtown court, and I'll turn it over to Michele for that.
Thanks, Aminah. So we started down this road when the youth mental health court at the downtown Toronto Youth Court at 311 Jarvis was developed by principally by Justice Brian Wiegand, who I've known for a really long time. And this is where, relationships are so helpful, because when he was really initiating this court, he said, I want to build research in from the beginning because we want to understand whether and how this is working. And so we worked collaboratively to do that. And so I'm just going to talk a little bit about it because it really sets up the whole impetus for the development of the mental health screening program that Aminah is evaluating, is going to talk about. So the Community Youth Court is the youth mental health court downtown, and the name was chosen with input from the community and from service users because youth really wanted a name for that court that wasn't a sort of stigmatizing name, which was why they stayed away from calling it a mental health court. And it's a resolution court in downtown Toronto that connects youth with mental health needs to community treatment programs. And the idea is that youth are seen in a separate court setting. It's more collaborative, it's less formal, and less adversarial than a traditional court. And it also is comprised of a core team of participants. So there's a dedicated crown, dedicated judges, and a youth mental health court worker who are working together in this court. And the goals as articulated at the inception of the court were to improve access to community treatment services, reduce case processing time, improve the well-being of youth, reduce recidivism, and increase community safety. And so just quickly, and you can go to the next slide, Aminah, that's fine. You know, one of the things that is important there, and this relates to Aminah's comment about theory failure, is one of the things we've really tried to do is to look at the relationship between mental health issues and reoffending, because there's sort of an implicit as well as an explicit assumption of this court that if you successfully address young people's mental health issues, then reoffending will be reduced. So we'll come to that in a second. But in terms of the implementation science framework, what I'm going to focus on here are questions around the description of the program. So what was this theory of change? What's the program's model? And who is the program meant for? Is it actually serving its intended population? And then in terms of that last piece of a practical fidelity assessment, really the question there is, how does the court address the mental health and criminogenic needs of the youth before it? And so to just have a look at that, we really took a multi-source, multi-method approach. So we interviewed service users, including youth and parents. We interviewed key informants, so crowns, judges, defense counsel, treatment providers. We reviewed program descriptions. We looked at court records, and we observed. So that Krista Davis was a student who took this on as a dissertation project at York University and spent a long time sort of on a biweekly basis when the court sat on, I believe, a Thursday afternoon to just observe what was going on in the court. So really trying to get a comprehensive picture of what was happening. And so in terms of that program theory, Krista really built a logic model because there had not been a logic model developed ahead of time, which is something that you could do when you're developing a program, is say, I'm really going to break down my goals and start with the end goal and back it up in terms of what am I looking for? What would be the outcomes that will tell me that I'm achieving those goals? What do I need to achieve those outcomes in terms of the things that happen, the activities, and then starting with the inputs. And so I'm just going to touch on a sort of a key part of this program theory, which was the idea that this youth mental health court worker, who was a key resource, a key kind of input to the program, would engage in screening of young people to see whether it made sense for them to be considered in this youth mental health court. That would lead to the identification of the young person's mental health needs, which could then facilitate referral to treatment services that would address those needs. That what would happen in terms of an intermediate outcome is that they're going to do better because they're being treated, and that would actually also lead to a reduction in recidivism. So that's really one of the key kind of assumptions or through threads of this court and of mental health courts in general. So that was just something just to document that clearly. So that gives us something then, for example, in an outcome evaluation that we can take a look at. So that's what you're looking for. We can look at that. But then the question is, how does that happen? And that's the importance of the process evaluation. So we'll take a quick look at that as well. And so when we're thinking about the description of the program, there's this question of who's in the program. And so what we found from the from this evaluation was that indeed 82% of the youth seen in the community youth court had at least one mental health diagnosis. And 89% had elevations on a normed and validated mental health screening tool. And this tool has been normed and validated on justice system involved youth. And Aminah is going to talk about that a little bit more in the context of the Pathfinder screening program. So, you know, we see that a lot of most of the youth have a mental health issue. A small percentage, but still notable, 6.5% of youth had no identified mental health needs. And at the same time, we discovered that almost a quarter of youth seen in the CYC were actually in that court before they had ever had their mental health screening. And so there were these processes that were a bit porous, I guess, to describe them in terms of how youth were getting into the CYC. So in some cases, I think defense counsel knew that that was maybe a good place for their client to be. And so they might initiate, Crowns might initiate those things, but there wasn't necessarily this systematic process for for screening for mental health needs before youth ended up in that community youth court. We also know, though, that there are a lot of youth, and Aminah is going to touch on this in her part of the presentation, before the courts who have mental health needs. I mean, it's a very strong majority. It's much higher proportion than in the general population. And so we also know that a lot of young people with mental health needs weren't ending up in the CYC. And there are lots of reasons for that. It's a resolution court. So in fact, if you want to, you know, defend against the charges, you're not going to end up in that court. But there were other reasons that came out, you know, as a result of the study. So concern about stigma, the fact that mental health needs can be difficult to detect, and that there was no systematic universal screening of youth in the downtown youth court. So say in courtroom 1 down at the old 311 Jarvis court. So that what we wanted to do, just go back for one sec to the other side of the slide, Aminah, is, so, you know, there's this, yes, there's when we think about that green, hopefully you're seeing a green circle there that's telling us who is in the court. We have a small percentage of youth with no mental health needs there. We have, you know, most of the youth there have mental health needs, but there are a lot of youth with mental health needs who aren't being seen in the court. So what we want to see is a much greater overlap, right? So that we're hopefully picking up at least of those youth who are interested in a resolution court or sort of a diversion, that they will end up there. And we don't want to see youth without mental health needs in that court. So that's something that we identified and wanted to address when thinking about next steps for the court. And so in terms of the fidelity assessment, you know, we really wanted to understand, how is this court addressing clients' needs? So what Krista did was she took a look at a subset of the youth in the court and said, you know, in some cases, the offense was in fact understood as directly related to a mental health issue. So, you know, for example, and when we talk about mental health, we're including substance use or substance abuse. So if you thought about a young person who committed a crime while they were high, or if you thought of a young person who committed a crime to get money for drugs or to get drugs, that would be an example of a direct connection. But in most cases, there's this really indirect relationship between mental health issues and the offense, right? And so that goes to this sort of theoretical issue of, what does that mean in terms of the relationship between mental health and the offending? Thinking about what was done in the court, we found that youth were connected to treatment services typically in about a month, with an average treatment length of 3 months. In half of the youth in the court, there was actually an addressing of what we would identify as criminogenic needs, although there was no systematic screening for those needs. And in a half of the cases, mental health needs were addressed in an intensive and specific way. So in a targeted way, although in a quarter of the cases, there was sort of some general unspecified treatment. And partly what that's about is a bit of a black box when it comes to knowing what treatment is happening. So there's connection between the youth mental health court worker, for example, and a treatment provider who might be giving information that the youth is attending treatment, and they might be giving some general information about sort of engagement and treatment, but there's not a lot of necessarily specific information shared, which means we don't necessarily know what's happening in treatment. But the other piece may be that treatment providers don't have the information they need from screening or from assessment that really directs what they should be addressing in treatment. And so two key recommendations that I'll try to quickly go over. One was that really we wanted to see a broader and more systematic screening for mental health issues for young people before the courts. So helping to ensure that the court is serving the right youth. So identifying those youth who do have mental health issues, screening out youth who do not have mental health issues, and really doing that systematically to hopefully allow for a quicker transfer over to the community youth court if that was the desired sort of outcome or pathway for youth, and to reduce case processing time overall. Also, though, needing to really, because in most cases, it's those criminogenic needs that are predictive of whether that young person's going to reoffend, not mental health needs. And I just should say that when we talk about mental health needs, we're really talking about either sort of internalizing types of issues, depression, anxiety, trauma, for example, and perhaps more serious issues. So Brian works in the area of psychosis, which typically isn't diagnosed with the age of youth that we're with. That's diagnosed more in late adolescence into early adulthood. But we're not talking about the kind of what we think of as externalizing mental health disorders, because they're so overlapping basically with criminal involvement or criminal behavior, conduct disorder, oppositional defiant disorder, and so on. But we need to understand those criminogenic needs so that we can establish the non-mental health factors related to offending, which can give some clear direction for intervention. So what needs to be addressed, and also it'll help us understand how addressing mental health issues will help in terms of these criminogenic needs, as well as enhancing young people's, overall health. So those were a couple of key recommendations.
Fantastic. That leads us to the Pathfinder screening program that came primarily out of those recommendations from the evaluation of the community youth court. So Pathfinder is a systematic screening program designed to identify the needs and provide the services that are identified for the youth at the downtown youth court. The intention was to offer screening to all youth at their first appearance, as well as an evidence-based mental health screener. We use the MAZY, if you're familiar with that, and a criminogenic needs screener based on an existing risk assessment tool. And the idea was that there's a structured relationship between the youth responses and the recommendations that are referred to at those court-based services. Michele mentioned that prior to Pathfinder, youth kind of found their way to the various resources and the community youth court. I don't want to say by chance, but it wasn't systematic, and that was a problem that was identified in that research. So this is an overview of what the screener looks like. The youth would be approached to find out if they're already involved in a court-based system. If they're not, they continue the justice process as usual, but they do collect a little bit of demographic information so that we understand the youth that are coming before us. If they are not currently involved, they would be informed about and offered the screening. They are free to decline because it is a voluntary service. If they decline, then they go through the rest of the justice process as usual. If they do accept, they complete the screening to determine their needs, and then the worker would provide a referral to the various programs that match their needs. So to evaluate this program, we did a process and outcome evaluation. And in the process evaluation, under that framework that I mentioned earlier, there were a couple things that we wanted. We wanted a clear description of the program. We wanted a clear description of the essential functions of the program, meaning like the activities, and operational definitions of the program components. What do you have to do those activities? Fidelity assessment was the last pillar of that framework, but we need to finish the outcome evaluation first to see if the program generated the intended outcomes. And in the outcome evaluation, the overarching question has a realist evaluation framework and asks, how does this work? What works for whom, under what circumstances, in what respects, and how? So we really want to understand, does this process work differently for different clients that come before the court? So the first thing was to understand the agency that was administering the screening. In part, their work is running the Youth Mental Health Court program at the Downtown Toronto Youth Court. And what we found is that they serve youth from 12 to 18 in Toronto, and that they provide services like education, housing support, substance abuse, mental health services, and that their values included a commitment to anti-racism and anti-oppression, meeting the mental health needs of youth, and a commitment to evidence-based practices. And so part of the reason this project was undertaken is that youth in this agency that serve youth at that downtown Toronto court realized that racialized youth appeared to be underrepresented in services, referrals to services, and in the youth mental health court. So that was really the why of how this program got started and took off. So continuing to provide context to this program, there were 5 staff that provided screening, but it was primarily one person. We found that there were 3 females, 2 males. The age range of these individuals was 30 to 39. There were a diverse group, and all of them had a postgraduate degree and were licensed to practice psychotherapy. One of the questions we asked was, what do you need to be able to successfully do this job? And so we talked about the qualities that they felt were important in doing this kind of work, which included being compassionate, empathetic, and patient, understanding youth, being able to interview youth, and a good understanding of mental health and criminogenic needs, and specifically the link between those things. With regard to the youth, all youth that were seen at the downtown Toronto court were eligible. There were no exclusion criteria. The youth were about 16 years of age at the time of their index offense. The sample was racially diverse, but Black youth appeared to be overrepresented. The sample was 32.6% Black, 26.5% white, and 18.9% multi-ethnic, which to the observations of people who work in the court is not reflective of the demographics of people who come before the court. There was no significant age difference between males and females, forgot to mention that. For the mental health screener, most youth had at least one elevation on the MAISY. Traumatic experiences were commonly reported we found that 75% of females and 2/3 of the males had traumatic experiences. So that was the most commonly reported elevation on the MAISY. Females had significantly higher scores than males on the angry and irritability scale, the depression anxious scale, and the somatic complaint subscales, of the mental health screener. Criminogenic needs, those ones that are directly related to criminal offending, we observed that females scored higher than males. So females scored an average of 8.56 as opposed to 6.45 for males, and that's out of a possible 18. So a significant number of criminogenic needs are being identified. And we also found that males and females differed significantly only in the family and education needs domains. So one of the things we did was created a logic model, which clarified the program's proposed mechanism of change and allows us to determine whether there's a causal link between the program activities and the outcomes. For this, the program theory was basically that with the inputs that are listed here of things like a working group, a project leader, access to court staff, and funding, combined with screening, would identify mental health and criminogenic needs, which would lead to an increase in referrals to community-based services, matching the youth's criminogenic and mental health needs, which would improve their functioning with respect to their mental health and criminogenic needs. These were the inputs that we identified, or the elements that in the logic model that we identified that were needed to start the program. So things like a working group to think through the logistics, legal consulting to make sure that nothing that you're doing is outside of the legal parameters that you need to function. In order to administer the program, you need a project leader, community service providers to refer people to, staff to screen, defense lawyers who are on board. You need access to detention center staff because some of the youth that you're going to need to screen are in detention. And then, of course, you always need resources, money, staffing, salaries, cell phones, laptop, that kind of thing. So the essential functions of the program are actually pretty basic. They needed to identify the eligible youth. They needed to locate and offer those youth for screening. If they consented, they needed to administer the screening and offer a program brochure that told them about the program. And they needed to refer to programs. Here is a list of the programs that were available to be referred to. That were available at the courthouse. And identifying the active ingredients of the intervention provides information for future court programs to be able to assess fidelity. So this is the part where we're telling what the program is. It also allows future stakeholders to make adaptations to the program to fit their context without compromising the fidelity. So after we identified what the essential functions were, the next thing was to describe exactly how those essential functions are accomplished. So this is one of the essential functions, and this is the operationalization of it, where we tell you exactly what the screener did. And this was examples of things that they did. And this part is important because not only do you need to identify what the essential functions are, you need to tell people how to do that. So with regard to what we found, the program reached, there were 443 youth seen at the court. 62.5 of them were contacted at their first appearance. Some reasons that youth, for example, couldn't be contacted at the first appearance was the youth couldn't be located, or the screener was not available that day. Ultimately, 31.2% of the youth were screened. 305 of them were not screened. And so the reasons that they weren't screened were various. For example, a third of them had info provided, but there was no follow-up. About a third of them were not contacted. About 20% of them were already connected to some kind of service, and 10% declined. So a majority of the youth were screened to a service that matched their needs. Rarely, the youth chose a different program, or there were a couple instances where the program they would have been referred to was closed during COVID. Of the youth that were screened, most of them were referred to the Youth Mental Health Court Worker Program. So that's here. That's not surprising in light of the fact that with the information that I shared earlier, that most youth had at least one elevation on the mental health screener evaluation. And that agency covers a lot of services: mental health, substance abuse, housing support, justice involvement, etc. So that's where most youth were screened to. 67.3% of youth were screened to that service. So the program started in July of 2019, but as we all know, COVID came to visit us in March of 2020. So the program had to pivot. The court had to pivot. to an online platform. First appearances in this court are still largely virtual. That was one thing that was not accounted for. And then also there's been a move to a new courthouse. So there were significant and unexpected changes that were made to the way that we originally designed the screener and the way it was ultimately executed for most of the time that the program was under evaluation. So we have the ability to, and will do some analyses of what happened in this program before COVID, when it was implemented as it was intended, and what happened afterwards, after there were circumstances that were just beyond everyone's control. So the outcome evaluation is the second part of this program evaluation, and the outcomes are directly mapped onto the program's stated goals. I mentioned a while ago that before the screener, there was no systematic way that youth found their way to the programs that are available at the court. I think there are 9 of them in total. And if you've ever been to a youth court, there are flyers everywhere. The youth and families are out of their element. So Pathfinder was designed to simplify that and make sure that youth have access to those programs. And they also found that the program knew that based on their knowledge of the youth that they served and the academic literature, there's a possibility that services are underutilized. So examples of questions that we have in the outcome evaluation are, do these upfront referrals decrease time from the time that they enter the court to the time that they're connected to services? Does it decrease the amount of time they spend in court because now they're involved in services before their case starts to get underway? Did the presence of Pathfinder increase referrals or change the proportion of youth that are in that youth mental health court worker program? And how often are youth needs matched to services? So those are kind of a couple of the questions that we will examine to see how well that logic model performed, in that, do our outcomes match what we intended to do? That's it for Pathfinder. And there's one last evaluation that Michele will briefly touch on.
And it is just briefly touching to say that we're engaged in a follow-up process evaluation and an outcome evaluation of the community youth court. So we're continuing, having started it in about 2012, 10 years later, what's happening in that court, in part and in large part because we now do have this systematic screening program. So one of the key questions for that evaluation is, how has that changed, if at all, the processes around the community youth court? So how youth get into that court, whether indeed the court has a more representative sample, for example, of youth, that would be seen in the downtown youth court than previously. So some of those same issues that Pathfinder was really intended to address, we're looking to see what that means in the community youth court, which of course represents a small portion really of youth who are being seen and supported through the youth mental health court worker program. So it's just kind of a nod to the fact that we're actively engaged in that now, and stay tuned maybe for next year for some results from that evaluation study.
That's all we have for you. So we'd like to open it up to any questions. Thanks for being with us here today, and happy to answer any questions.
Okay, so thank you so much both. That was a very, very interesting talk. And I know myself, I was writing down all sorts of notes and things. So I'm sure there's lots of questions in the audience. So a few that came up, just one of the first ones was from Norma. Just, Aminah, is it okay if anyone needs to contact you with any follow-up questions, is that
Yes,
okay?
Please.
I wonder maybe if you're able to put your email address in the chat. Sure. That might be helpful. Norma also asked the question, does this court address diversion?
So I'll try to answer that question, and I'm not the expert. So one of the things that I'll just say has been interesting for me over the past 30 years is trying to take what I understand in terms of my knowledge as a psychologist and as a researcher and the kind of questions I have, and have a really good, clear understanding and dialogue with the partners that we work with. So whether it's our court partners or whether the folks at the Ministry of Children, Community and Social Services, who over the years have been tremendous, and we've had a lot of data from them, from the Ministry of the Attorney General, where I have my question, and I feel like sometimes there's this translation gap because I'm not a lawyer, I'm not sitting in the sort of the legal system. So I hope that this is at least a partial answer. You know, the community youth court in some sense is considered a kind of a diversion. And so it's a resolution court. So, you know, the youth is not contesting charges, and the most common outcome. So I don't know that it's, you know, sort of, I guess, strictly speaking, considered an EJS. But the most common outcome for youth seen in the CYC is that their charges are withdrawn. So one of the ways that we described how this court works in the evaluation was in some sense, the sort of the work to be done is front loaded. So, you know, if you had a young person who was, you know, pled guilty or found guilty of an offense, sentence happens, and in the context of that sentence, there might be some intervention that really is about mental health treatment or, you know, intervening on a number of things, right? In the CYC, really that's getting front loaded, right? So the youth is being seen, there's an assessment done, there's referral for services, there's conversations back and forth regarding what's happening with those services. Are they going okay? And there'll be, you know, so periodically that will come up and youth appears in court. The judge is asking how things are going. The youth mental health court worker and the Crown have connected around that. And ultimately, in many, many cases, the outcome then was, you know, the youth seems to be on a good path. You know, they're satisfied with what's happened and the charges are withdrawn.
Great. Okay, there's another question from, I'm not sure the name, but the question was whether GLADU principles are considered in the screening process or during the court process for all Indigenous youth in the CYC.
Yeah, that's a great question. And in fact, you know, the way that Pathfinder was set up was if a youth identifies as Indigenous, the referral actually is going to be to either, I don't know if it's whether it's Aboriginal Legal Services, or to the Aboriginal Youth Court, right? So there's also in the Downtown Youth Court, there's an Aboriginal Youth Court. So they don't end up in that regard, the sort of pathway isn't to Youth Mental Health Court Worker Program, it's to ALST or Aboriginal Youth Court. And so that's where those kinds of issues would be. So we really don't see Indigenous youth in the CYC, for example, and few, because again, there's a choice element to it. So there would be some, I think, right, Aminah, but a very small number of Indigenous youth who would be participating, for example, in the Youth Mental Health Court Worker Program.
Exactly. They can decline, like these are all voluntary services, but that's one of the first elements in that flow chart that I showed you. The very first thing that they're asked is, do they self-identify as Indigenous? If they are, they are offered either Aboriginal legal services, I believe is the service provider. If they choose, they can participate in that service. If not, they're still eligible for any of the rest of the services, but I believe that's where the GLADU factors would be considered, is really, like Michele said, front-loaded in making sure that youth are diverted to services that meet their needs and address those issues before they're even further entrenched into the court process.
Great. Raf had asked a question about who does the pre-screening of the youth before they appear for court.
Great question. There's a Turning Point Youth Services is the provider of the Youth Mental Health Court Program at 311 Jarvis, the Downtown Toronto Youth Court, and those are the people who provide the Pathfinder screening process. So when I was talking about the needs, the qualities of people who provide this service, that's who those people are. They're trained as youth mental health court workers, so they're coming with that lens already. But those are the people who are also providing the screening as well.
And I see Rajesh has had their hand raised. I'm going to see if I can. I'm not sure if you're able to type your question into the chat, or I can maybe try to unmute you, but I hope I don't mess something up as I'm doing that. Maybe as I'm figuring that out, I can ask a question. You mentioned earlier around and I'm speaking from the healthcare perspective, that sometimes there can be differing levels of consent or collaboration with other care providers. Is consent for that information sharing part of that screening process when they do enroll? I know something from working at a hospital. Sometimes we don't necessarily have that linkage with the court system, though it would be very beneficial for kind of mutually supporting young people. And I just wonder if you might be able to comment on that.
Yeah, so just from what I know, it doesn't happen at the time of screening because they haven't, it would happen once a youth is referred. But I don't know, Aminah, if they're referred to something other than the CYC, so the actual youth mental health court, I don't know that there's information shared back and, well, I guess there would be at that point with the youth mental health court worker, and that would involve a consent process for sure. But Aminah, you may have more specific information on that than me.
Let me make sure I understand the question. You want to know if, as they are entering services, if there's a
Yeah, or
consent
just
provider?
as they're getting there, like, is there an opportunity for like youth mental health workers, once they get into court, to be able to share, if they're linked with a care provider, say at a hospital or something, that they're able to kind of work collaboratively as they're early on in this process?
Yeah, so that would be done through a consent process for sure. Yeah.
So I'm still trying to figure out how to unmute people. So I'm going to ask one of the other questions that had come up. This is from an anonymous attendee. It said, a lot of stakeholders in the criminal justice system express some caution about universal screening system in a court context, especially in light of privacy interests.
Yeah.
Some of the issues identified include who will get access to the information disclosed in the screening process, what can be made of the information disclosed as part of the screening process, i.e., even if not used now, could it be used later? And how in depth should the screening process system be, questionnaire, full assessment, etc. I wonder if you can comment on the experience of the Pathfinder in relation to these privacy concerns. And I think it's a great question.
It is a great question. Yeah, yeah.
Fantastic. It's actually one of the things that came up. So we interviewed lots of stakeholders. We interviewed judges, we interviewed lawyers, et cetera. And that was one of the things that came up as a concern by specifically defense counsel when we interviewed them about where is this information going? Like, who has access to this? So the information that Turning Point collects is only restricted to them. And so they obviously obtain consent when they youth. It's my understanding that that information is not shared with anyone unless there's like a court order or something like that, or the youth's consent. So part of the youth mental health court worker's role is to serve as a bit of a liaison between the youth and the court. So information that's shared is shared with the consent of the youth, but not aside from that, is my understanding.
Yeah, it's health information.
Definitely a concern that came up. It's part of the at the end of the dissertation where I come kind of unpacking what happened with it. It's a significant theme of concerns about privacy and balancing the youth's need for privacy as opposed to connecting them to their needed services.
And I'll just sort of hop on that just to add to what Aminah said. You know, it's obviously a tension, right? So if you're taking a kind of strict, you know, due process adversarial, that's what the system is. You don't get into all of this. We're not there to help people. That's not what it is. It's not a helping system. It's a criminal justice system. So why are you doing any of this? So that would be one kind of extreme end. And then the other end, you know, would be some sort of, you know, blending that's makes it difficult to discern, you know, well, are we helping people by getting, you know, obtaining sensitive personal information when in fact, you know, in the case of Pathfinder, it's a screening program. So it's not like youth are saying, yes, I'm admitting guilt. I want to resolve my issue, which is, you know, what happens in a resolution court like the CYC. You know, they have a defense. So why are you digging in and getting all this information? And in fact, I was involved years ago with a group of people that were really looking again at trying to obtain mental health information, you know, on really vulnerable people who are involved in the criminal justice system. And, you know, what kept coming back was, yeah, but, right. And it's a fair thing. So I also will just flag with the original community youth court evaluation, a whole dimension of what we were looking at was really around due process rights and looking at this issue. It also came up of, you know, obtaining and how is information, sensitive personal information, obtained and used. Are we net widening with these programs? Are we pulling people in that we wouldn't otherwise pull in? Are we actually prolonging people's engagement in the criminal justice system by doing this helping, quote unquote, right? And we addressed all of those issues in the first evaluation, and it didn't net wide. It didn't extend their time in the system. There were you know, issues raised, and we certainly had recommendations around some of this issue around privacy and sort of autonomy over personal information, and just being sensitive to those dimensions.
Excellent. Felicia had asked if there's any way to get involved in any capacity, even with volunteering, having a criminology background, that she was interested.
That's a great question. We can connect afterwards. I put my information in the chat. Yeah, we can connect afterwards, and I can answer that question for you. Like, I don't know, I'm just evaluating this program, but I can refer you to some of the community resources where these activities are happening.
And actually, maybe a follow-up to that question. You mentioned, Aminah, in your part around this being a voluntary program, the screening program. And I wonder, and if I'm remembering, the majority of people didn't necessarily participate. And I wonder if you can comment on kind of, because we often struggle a lot with this in our line where people aren't buying what we're selling. And I wonder if you can comment on, you know, what that process looks like, and if there's roles for, you know, even people with lived experience who might be a part of this to maybe increase that piece. I don't know if that was necessarily part of your research at this point, but if you might be able to make any comment on ways to get more people at least considering enrolling in something like this.
It is not part of the questions that I had, but it's part of what I'll be thinking through as I continue to write the discussion and the implications for future research. Most youth didn't participate. There were 10% that just declined. No, thank you, I'm not interested, which is their absolute right to do. But about a third of youth didn't get back in touch with the youth mental health court worker. And we don't know if they weren't interested, if the information didn't make it to them, if they didn't have the opportunity to consider or ask questions. And part of that, I believe, has to do with the fact that transition from an in-person live experience to a online experience. And one of the things that was alluded to is that now the screener has to contact a third party, an intermediary, in order to contact the youth. And so that was a concern that came up. If I could return to could you repeat the second part of your question?
Was just, I think you've answered, was just, is there a way, or the piece around whether or not that the kind of buying what they're selling, and you know, we've found, I know you integrated in your evaluation interviewing a lot of young people themselves, and whether or not there was any value for somebody, say, with lived experience who might have been through the program, in kind of, again, providing a bit of a sell to that screening process. But
I'm going to hop in for a sec. Yeah, so we haven't interviewed young people in the context of the screener, just for logistical reasons. And so that would certainly be something to talk to them about. I mean, it is interesting that it was the smallest kind of number in terms of not participating in the screening were youth who actually said no. So there are these other barriers that are more than people saying, yeah, I don't want to do it. And so, you know, now that often youth mental health court workers are going through the youth council, lawyers have various reasons, including some of the ones that were raised in the earlier question, right? I don't think it's a good idea for my client to do this, but even just getting hold of them is really difficult, right? And so our understanding is that first appearances are continuing to be virtual as opposed to. So what the youth mental health court worker used to do was go show up in courtroom 1 at 311 Jarvis and had the list, you know, from the docket of the youth that was appearing and would approach them, right? Or they'd go down to the cells. And so they're not able to do that anymore. So there are some really just very basic logistical issues, even more than issues of sort of buy-in, although that part of it is important too. And the idea of having people, you know, who have been service users, who have lived experience is, I think, a great idea. I know one of the, at least used to be anyway, one of the people on the kind of little committee at 311 Jarvis, it wasn't a young person, but it was a mom, you know, of a young person. So again, having that engagement, having stakeholders involved who certainly have been service users of the system.
And just one last comment from Norma here. Just she wanted to thank you for the explanation regarding diversion. Just said, I'm very concerned about the overrepresentation of Black youth in the justice system, and hope that when she's speaking tomorrow, so I'd encourage everyone to participate there, to watch that. She'll speak tomorrow about trauma, and folks can give some insight about how we can decrease trauma in Black youth within the system. So.
And you know, I'm really interested in that talk, Norma, and I have a colleague who is a criminologist who I've worked closely with for, again, many years now, Carla Cesaroni, who has been looking at the experiences of young people who have been in custody. So whether it's, excuse me, whether it's custodial dispositions, pretrial detention, she's looked at this over years. Looking at issues around males versus females, has done cross-national work in Scotland, where they actually have young people kept in separate institutions. They're not in sort of, you know, this is with young adults, very young adults who aren't in the general population. One of the themes that comes up over and over is this theme of trauma. And, you know, in the moment that we're in now, where there's a sort of focus on trauma, I think, in a kind of gendered context, one of the things that, you know, Carla really tries to bring to the fore, and that we have data on, and that's one of the reasons we were sharing this MAISY, the main sort of elevation, which means that this is at a kind of caution level, that you should, you know, this is something to flag and be concerned about, was that trauma was the #1 elevation for males and for females. Sometimes the nature of the trauma is different. And just, you know, so that, you know, Norma, you know, one of the things that I think this is so interesting when particularly when we think about incarcerated boys, is this relationship between trauma and their developing sense of masculinity as well, and masculinity in a carceral context. And these things are really interwoven. And so, yes, this question of overrepresentation, of how this linkage between traumatic experiences, and then, you know, how those may be pathways to, or have expressions in, you know, in intersections with criminal justice. So, yeah, really interested in that as well.
Okay, and I see Madison has her hand up. I'm going to try to allow you to talk, Madison. So if you're able to unmute yourself.
And it may be set up so that participants can't unmute. Can you unmute her, Brian?
I'm trying. Let's see. I have the option of asking to unmute. Or Madison, if you can add your question to the chat or to the Q&A, that might also work. No. Okay. I think her hand may be down now. So I'm just gonna put out one last call for if anyone has any further questions or any further follow-ups. Okay. Michele or Aminah, any last comments before we wrap up?
Not for me.
And I would just say, you know, I'm really grateful for the opportunity to work with wonderful people in the system who are interested in understanding things from a kind of, an evidence-based perspective, that have a commitment to that, to evidence-informed practice, and that sort of real value of collaboration, which I think is wonderful. And that's just something that has sustained my program of research, as I said, for like 30 years. And it wouldn't be possible without that. And it's been tremendous. And so we have many people to sort of thank for that, but certainly Mr. Justice Brian Wiegand, Justice Brian Scully, from time to time, Justice Marianne Cohen, and now Justice Maria Sirivar. So, really great partners at the downtown Toronto. Really interested to see, I haven't set foot in the new courthouse, but what that will mean for young people, because from a kind of, youth advocate perspective, there's something about that courthouse that we feel kind of goes against the spirit of the Youth Criminal Justice Act in terms of really keeping young people separate from adults. So to be continued. And it'll be interesting to see what efficiencies are gained, because that's the purported purpose, right?
And I think that is 100% the spirit of what the Association of Justice and Treatment Professionals is really aiming to do, is looking at these ways. We're all doing really great, wonderful work, but at the end of the day, if we're not working together, we can definitely make things better for all of us and all the people that we serve and are in our world. So I will take the time to thank you both for a very engaging and thought-provoking presentation. And I certainly will be following up with you. I see, Aminah, you had put it looks like Dan had put in your email address again. So if you have any follow-up questions, it sounds like I'm volunteering you both to answer those questions if people want to email out. I certainly
Absolutely.
And so just wanted to thank you on behalf of the Association of Justice Professionals, just for your time and your insights. And for all of the participants or everyone who is watching today, this is just the first of 6 presentations over the course of the next 3 days. So today at 3, there will be a presentation on the treatment for incarcerated populations, specifically around opioid agonist treatment. So that's at 3 p.m. And hopefully you can participate in that and the rest of the presentations this week. And thank you so much, everyone. And hope you all have a great rest of your day.
Thank you, Brian.
Thank you
Thank you
all.
very much, everybody.
Bye.